So in this section I'll be discussing court applications. A court application should be made when the parties feel that they cannot agree on the terms of the new lease. Now, either party can initiate the application to court, but there are timelines as to when either party can make the application to court. If the landlord serves a Section 25 notice on the tenant, the application can be made by either party after service of this notice. If the tenant serves a Section 26 notice on the landlord, the application can only be made 2 months after the tenant has served the notice. This is to allow the landlord 2 months within which to decide whether or not they want to oppose a grant of a new lease. There are deadlines for making court applications, and this is known as the statutory period. The statutory period in the case of Section 25 notice being served will be the date which the landlord specifies should be the termination date of the current lease, and this can't be a date earlier than the contractual expiry date of the tenant's lease. If the tenant serves a Section 26 notice on the landlord, the statutory period will end on the date which the tenant proposes as the commencement date for the new lease. If either party misses the deadline, misses the statutory period, then the parties have no right to apply to court to determine the terms of the new lease. The court application procedure is relatively complex, and if you are considering making an application to court, you should always do so with legal advice.